वेलकम व्यूअर्स, मैं हूं अनिसfarooqui और आप मुझे देखते हैं मुख्तलिफ़ नेटवर्क्स पे और हमारी गुफ्तगू को आप बग़ौर सुनते हैं, जांचते हैं, उसके लिए बहुत बहुत शुक्रिया। और हम चाहते हैं कि आप तक कुछ ऐसी इंसाइट्स लाई जाएं जो कि ना सिर्फ आपके लिए एजुकेशन का बाइस हों बल्कि बहुत सारे कन्फ्यूजन्स, इबहाम भी दूर करे। देयर इज़ नो एम्बिग्यूटी, और इस तरह का कोई भी कन्फ्यूजन होता है या जो भी मिस इन्फॉर्मेशन या डिस इन्फॉर्मेशन होती हैं उसको हम दूर कर सकें। यही दूर करने के लिए आप सबका बेहद इसरार भी था और हम चाहते भी थे कि किसी तरह से आप तक असलियत लोगों चीज़ों की लाई जाए, कानूनी पहलुओं से भी और उसके समाजी और सोशल और पॉलिटिकल जो एस्पेक्ट्स होते हैं उससे भी हम आपको बाखबर रखना चाहते थे। आपके इल्म में होगा नाजरीन के एक केस लंदन में चल रहा था अल्ताफ़ हुसैन साहब के लिए, प्रॉपर्टी का मामला, जिसको अमीनुल हक MQM पाकिस्तान एक उसकी पार्टी थे और उन्होंने इस पर जो है कहा था कि हम इस पे दावा रखते हैं। और ये वो प्रॉपर्टीज़ हैं जो कि लंदन में ख़रीदी गई हैं, बहुत सारी उसके एड्रेसेस हैं जिस पे हम आगे चल के बात करेंगे। और उस पर अल्ताफ़ हुसैन और उनके कारकुनान रह रहे हैं या वो किराए पे दी गई हैं, वो किसकी मिल्कियत हैं, किन पैसों से ख़रीदी गई, किस ट्रस्ट की ज़िम्मेदारी थी, ये सारी बातें आज हम डिस्कस करेंगे। और इसको डिस्कस करने के लिए हमने दावत दी है, लंदन से हमें ज्वाइन करेंगे काउंसल जिन्होंने अमीनुल हक साहब का ये मुकदमा लड़ा लंदन की अदालत में अल्ताफ़ हुसैन के ख़िलाफ़, और उसके बाद जो फ़ैसला आया उस फ़ैसले पे भी बात करेंगे। सबसे पहले हम वेलकम करते हैं बैरिस्टर नज़र मोहम्मद साहब को। अस्सलाम वालेकुम जी।
थैंक यू। वालेकुम सलाम
सर, थैंक यू वेरी मच फॉर योर टाइम। आई एम इन कैनेडा, यू आर इन लंडन, देयर इज़ अ टाइम डिफरेंस एंड वी आर ऑल ऑक्यूपाइड। Really appreciate that. So I don't know, I was just trying to explain to my audience what is happening with this court battle in London with Altaf Hussain and Aminul Haq, MQM Pakistan, MQM London, and finally it was determined by the court that there is only one MQM which is in Pakistan right now. Why have they decided that? So there may be a logical, conclusive argument that they have based on which they have decided that Altaf Hussain is no more MQM and MQM is MQM which is in Pakistan. So let's talk about that a little bit.
Of course, the competing positions were this, that the MQM London, which is based in North London here predominantly, they are the defendants, and they are described as the active defendants in this particular case. The competing position with Sayyid Aminul Haq and the MQMP in Pakistan was that at always the MQMP was and remains the MQM.
Okay.
There was a time in 2016 September, after events of August 2016, that precipitated in a splitting of the MQM into two. The splinter group... You
are referring to the 22nd of August, Pakistan, infamous Pakistan Murdabad thing, right?
Yes, I mean, we can address that, but they just addressing the immediate point of the existence of two parties.
Okay.
So 16th of September 2016 was our position that the MQM London splintered away from the MQM, and the MQM, the original, continued, and then sometime along the line it changed its name to MQMP. Or rather, all it did was drop the apostrophe from MQM apostrophe P, which was the MQM, and removing the apostrophe did not change the party, did not change the party ethos or substance. It was our case, and that case was accepted by the High Court judge in our favor.
Okay. Okay. So that means it has been now determined by a UK judge that MQM legally and constitutionally, which is MQM's constitution, is the one which is in Pakistan at the moment, led by Khalid Maqbool Siddiqui, Mustafa Kamal, and the colleagues, and so on. So that has been set aside, and there's a big setback. So Altaf Hussain, who's known to be the father figure, who's known to be the founder member of, he does not have anything to do with MQM Pakistan. So he did not fight that. Was there a lack of interest, or what was it?
You see, Altaf Hussein's case was that, just as you said, you described him as a father figure. So his position was, I am the father figure, I am the MQM, and without me, there is no MQM.
Okay.
That was his position. The judge rejected that proposition and said that the MQM is an association, an unincorporated association, much like your cricket club, football club, and members come and go. And the existence of that association is independent of any one personality. Mm-hmm. Altaf Hussein's position was that he was the father figure, and he was the benevolent character to whom everything was given because he was so. That was rejected soundly by the judge. The judge said, the position is, you resigned twice at least by your own evidence in 2015 from the MQM. It survived. It went on. Mm-hmm. They called you back and you came back.
Okay.
But on the 22nd of August, when you made the hate speech, and when the party in Pakistan in general decided to say, we no longer wish you to be our father figure, you then offered an apology on the 23rd of August 2016, in which you categorically said, I hand over all power to the Rabta Committee. And that is what the judge then said, well, that is your position. You were left with no role. You voluntarily gave everything up.
Yeah, but Mr. Mohammed, historically, I've followed Mr. Hussain for so many years. Historically, right. He has been doing this consistently, resigning 5 p.m. and then 7 p.m. he say, okay, I am insisting by my workers and my colleagues, I'm just coming back. So he just does this kind of musical chair every now and then. This is historically proven in the national television. He will do a 3-hour-long press conference and say, okay, I am resigning, I have nothing to do with MQM, and then 2 hours later he say, okay, no problem, I am coming back. So this is kind of a norm for MQM.
But that was his downfall.
Okay. But technical grounds and legal grounds, that did not play out well.
Let's address it technically, and then in terms of a sort of a social context to the MQM. Mr. Hussein's position was that he never was a member of the MQM. He never held a party position. Mm-hmm. And that was simply his version of events was, or reality was that because he was the father figure, he didn't need to formalize his relationship in any way. Mm-hmm. So when he then voluntarily gave up that position on the 23rd, like you said, this whimsical tantrum that he would have, and then will come back. Well, he threw out, like a baby does, in a tantrum, he threw his position out of the pram on the 23rd because he wrote it all down and then he put it up on the MQM website, and it remained there until 2020, unchanged. Mm-hmm. And everybody thought, oh, this is the MQM functioning normally. But legally, no, it wasn't. Mm-hmm. Because if then we look at the events of the 16th September 2016, when, if you recall, as you say, you've been following Mr. Hussein's life, there was a proposition passed, or a proposal passed in the Sindh Assembly that was supported by the MQM members, after the 31st of August 2016, September, this peaked, this irritated and riled with Mr. Hussein, who then joined a splinter group of people who left at that point. Yeah. But you see, the difference between his previous tantrums and this tantrum was, this was a formal letter of resignation, of abandonment. Okay. And that is what the court accepted. Okay. And again, that was his downfall. So the MQM Rabta committee did not beg him to come back on this occasion.
This time it did not happen like usually it used to happen. They will beg him over they will cry, they will, log jama honge, wapas aa jaye, bhai Allah ka wasta hai. But he did, this time nobody said anything. They said,
no,
bygone.
And this is what he didn't seem to want to accept. And then you see, his other complaint was that when this happened, on the 31st of August 2016, Dr. Sattar organized for a Rabta committee emergent meeting. The constitution allowed that.
Dr. Farooq Sattar called an urgent meeting of entire Rabta committee in Pakistan.
That's right. And it was described as an emergent meeting.
Okay.
And
what year was that? What month?
Emergent.
Okay.
It's essentially another word for urgent meeting.
No, but what I'm looking for the time frame, like when was it?
Oh, that was on the 31st of August. That was in the morning.
Okay. So about 1 week after the hate speech.
Yes, that's right. And in the morning of the 31st of August, the reason why we say emergent is because constitutionally, the notice period was very short. And that is what the constitution allowed. When that meeting occurred, certain resolutions were passed. One of those resolutions that were passed was that any reference to Mr. Hussein as the Qayyid or the father figure,
Bani MQM, Ruhani Abba, sab kuch. Yeah.
Yes, was removed.
It was removed. It was removed from the papers now. This time, the Rabta committee deleted it.
Okay. Now, the other significant point there was that the Rabta committee was bound by a clause called 9B in the constitution that existed from 2012 up to 2016 in one form or another. And 9B basically required the Rabta committee to consult Mr. Hussein on any major issue. Okay. So Mr. Hussein's case was, well, I was never consulted when the amendments were taken on the 31st of August.
So नाज़रीन basically जो नज़र मोहम्मद साहब बता रहे हैं वो यही है, और आपके इल्म में भी होगा कि जब भी कोई ग्राउंड पे फैसले होते थे, चाहे वो किसी की तैनाती के हों, किसी को टिकट देना हो, कुछ झगड़ा हो, उसके बाद वो लंदन जाता था, फिर एक फॉर्मल सा स्टेटमेंट आता कि कायदे तहरीक अल्ताफ़ हुसैन ने फैसले की तौसीक कर दी है. सो बेसिकली ही हैज़ गिवन हिज
he's given his consent.
consent.
And the matter would then become.
So ये क्लॉज है, ये बड़ी इंपॉर्टेंट बात है, क्योंकि इस पे भी उनका मौक़िफ़, उनका जो पॉइंट है वो यही है कि कोई भी फैसला राब्ता कमेटी की चाहे इमरजेंट मीटिंग में क्यों ना हो, उसकी अल्ताफ़ हुसैन ने तौसीक ज़रूर करनी है कॉन्स्टिट्यूशन की क्लॉज 9B के तहत.
9B के वजह,
राइट नाउ
9B के वजह से.
तो फिर जब ये नहीं किया तो फिर अल्ताफ़ हुसैन लाइक पॉइंट ऑफ व्यू इज़ राइट इन अ वे कि मुझसे तो पूछा ही नहीं गया. So why?
Yeah, okay. Again, let's look at that. This is the reason why.
9B. Explain me 9B. That why was 9B. It not consulted or his approval was not sought?
Okay. So for that particular point, we will have to go back to the events of the 22nd of August and the subsequent letter that was issued on the 23rd of August.
So this is between 22nd of August and 30th of August when this emergent meeting took place.
Yes. The emergent meeting took place on the 31st.
31st, okay. But on 23rd of August, some events took place.
That's right.
Okay.
But critical to that emergent meeting was the letter that was issued by Mr. Altaf Hussain in his own words, and then it was relied upon in other parts of his career before the 2006, well, before this case anyway, was relied upon. And principally that letter that I'm referring to, the 23rd August letter, that Altaf Hussain abrogated all power in favor of the Rabta Committee, was our position. He gave up all the power. So therefore, when it came to the 31st of August, the Rabta Committee did not have to seek his permission, because he gave them the power to do all of the things that he could or would have done.
And that was on 23rd of August, you're saying?
The 23rd of August letter. Yes.
So up until the 22nd of August, to the day of the doomsday, the hate speech day, he had that power to be consulted legally, yes, and there would be no decision binding unless he has given his approval. But on 23rd of August, in the light of his letter that I am giving up all my powers and it is entirely up to Rabta Committee to make decisions, he had no right to be consulted. That's what I'm trying to understand.
That's exactly it.
Okay.
It's simplistically put, Clause 9b is rather a peculiar animal, but very simplistically put, and we're not having a legal argument in court.
Okay.
That is more or less what it said, yes.
Okay.
And so then the events of the 23rd are important to the events of the 31st.
Exactly.
And then you see the other issue, which Altaf Hussain himself admitted in cross-examination in response to my question, which was, Mr. Hussain, between the 31st of August and the 16th of September 2016, you remained silent. And his answer was yes.
Yeah.
And you supported.
That was a long period, because he does not wait that long to revert back to the whatever decision were made. So basically it took him a long time.
But it was long enough, you see, short or long, that the importance of that interim period, interregnum, was that Mr. Hussain was deemed to have accepted whatever took place on the 31st of August and the 1st of September, regardless of what his personal views were. He accepted that.
Right.
And therefore, by keeping silent, the judge accepted that as being support for Dr. Sattar. And he also accepted in cross-examination that there was no new party between the 31st and the 16th of September. So the 31st of August to 16th. That the significance of that is the continuum of the MQM.
Okay.
Now, you see, when you have a train journey, this is how I described it. You're going along on a train journey and you come to stop A, you pass that, but you come to stop B, and then the carriage splits. So you have train B going in one direction, south, and the other train A going along straight in the line that it was.
Right.
Mr. Hussain became the train south B, and that is the new party. And the judge accepted that description and that analogy. Okay.
So now we understand that after 22nd of August, there was a 23rd of August and the 31st of August where everything happened. So he is no longer a leader of MQM in any form or shape, right?
Because he resigned, he gave up.
So this has been established. Now, going back to the original case, which is by Aminul Haq Saab, regarding the properties that Altaf Hussain is residing himself, renting it, or giving maybe some party workers living there in some of the houses. Paying rent or not paying rent is another issue. And if the rents are being paid, where are those rents? Who is now custodian of those rents, and who was throughout this period of so many years was custodian of these properties, the rental income and whatnot, right? And so this is what I want to know for my benefit of my audience, that Aminul Haq has gone to the court asking for the custody of these properties and the incomes, right?
Yes, that's right.
Okay.
That's right. Now, to answer your question, the first part of your question,
Mm-hmm.
who are the custodians?
Right.
Who were the custodians? Well, there's been no change in that yet. The custodians were as trustees in terms
I want to
of.
draw a line here. I want to draw a line
Yes.
here for the benefit of my audience, because we mix things very quickly. Actually, there are two lines, which second line is going to come a little bit afterwards. So the case of ownership of MQM is finished here. It's been decided that Altaf Hussain is no more MQM. MQM Pakistan is MQM, and that is done. Now this separate issue of trustees and the properties, now we're going to talk about that, and this has nothing to do pretty much with the previous one, right? So
That's right.
Yeah. Okay.
This
This is actually, Mr. Mohammed, this is your UK matter, as far as I see. These are the laws, the rules, regulations, the acts of UK, under which a trust is run or operated or executed, or they have to follow those bylaws.
Yes. You see, to give you context, there were 7 trusts.
Okay.
Okay. 6 are still existing.
Mm-hmm.
The 7th was related to a property that Mr. Hussain sold.
Mm-hmm.
This is the sort of power that he exercised, that he had no regard for rule of law or the rules of the MQM, because he thought he was the personality and he was the person who was the MQM. So he made no difference between his personal and business, so to speak.
Yeah.
So Mr. Hussain got rid of one property. That is the property that was sold for about £600,000.
Okay.
And it was split between himself and another MQM member. We say it's not even an issue. It was accepted by Mr. Mir that the 200,000 at least went to Mr. Mir, and the remainder went to Mr. Altaf Hussain. What became of that money would be the subject of a tracing order ultimately.
Okay.
Right? Then we look at the other properties that exist. Now, Altaf Hussain's own, the house that he lived in.
Do you know what address was that? The one which got sold?
12, that was 45 Brookfield, I think.
Okay.
I forget the name.
And what year it was sold?
When was it sold?
Yeah, when was it?
I think that would have been sold probably about 2000, some 2006, 7, something like that.
Okay.
But I don't quote.
And that was sold for close to £600,000.
600,000. So in today's terms, that would have been worth a lot more money than then. So when we go tracing, we will have to ask for, the interest.
Was there a paper trail of that money? Like who?
There was a paper trail because the solicitors, because I think it was very recent, the solicitors still maintain the conveyancing file, and we will be able to get the conveyancing file. Now that we've been recognized as the beneficiaries, we will have access to all.
So let's see, that property, they got rid of it on their own without following the procedures of the trust and the governing laws in UK.
That's right, and that's in breach of the trust.
So that is one of the breach of the trust, right?
Yes, and the simple fact that they bought the case as trustees against the beneficiaries, or defended the case against the beneficiaries, is a significant conflict as recognized in the judgment itself. Mm-hmm. So they're in breach of trust. The other issue, which
may I ask who were the directors on this trust? Like what do you know those people?
Well, the directors are very simple. All of the defendants. So let's reel them off for you. So the defendants, Altaf Hussain was a trustee, who is in England and is a British citizen. Iqbal Hussain, who is the brother of Altaf Hussain, who lives now in the United States and is a British and US citizen. Mm-hmm. Mr. Tariq Mir, who is a British citizen now and lives here in North London. Mm-hmm. Muhammad Anwar, who's now deceased because of COVID, I think. But he was a British citizen, so he was a trustee. And then Mr. Iftikhar Hussain, who I believe is the cousin or nephew of Mr. Altaf Hussain. And then Qasim Ali Raza.
Okay. तो कासिम अली रज़ा साहब जो कि इस वक्त कन्वीनर या डिप्टी कन्वीनर टाइप की कोई चीज़ चल रहे हैं, इकबाल हुसैन जो कि अल्ताफ़ भाई के भाई हैं, अमेरिका में रहते हैं, वो हैं। इफ्तिखार उनके चचाजाद भाई हैं, कज़न हैं, वो रहते हैं। एम अनवर साहब मरहूम और तारिक मीर साहब, तारिक मीर और एम अनवर, दे गॉट डिफ्लेक्टेड फ्रॉम MQM अर्लियर. So did they have to play any role in this trustee, or they are also liable and responsible for this decision?
Well, we sued them all as
sued them all.
trustees.
So they were acting as a defendant.
They were defendants.
They were defendants.
And remain defendants. But the position of Mr. Mir and the position of Mr. Anwar was such that they signed a consent order very, very early on in the proceedings to say that we, Mir and Anwar, recognize the claimant's case and we accept his position, and we wish to take no part in these proceedings. So they were silent. And
so Nazreen, basically M Anwar साहब और तारिक मीर साहब ने अमीनुल हक और MQM पाकिस्तान के मौक़िफ़ की तायीद भी की और ये इस बात की तस्दीक भी की कि वो ये बात समझते हैं कि ये केस जो है जायज़ है और इसमें MQM पाकिस्तान और गरीबों और मुस्तहक़ीन और शहीदों और असीरों का हिस्सा होना चाहिए, ना कि अल्ताफ़ हुसैन और उनकी जो रजीम वहाँ बैठी हुई है जो कि मुफ्त में वहाँ रहते हैं और वहाँ पे मज़े लूट रहे हैं। जिन सब के हमने नाम बताए उनमें कुछ उनके अजीज़ भी शामिल हैं और एक उनका कॉमरेड कासिम अली भी शामिल है। तो ये दिस इज़ द सिचुएशन एंड दीज वर द ट्रस्टीज़, सो आई एम प्रीटी श्योर दे मस्ट हैव द साइनिंग अथॉरिटीज़ ऑन द चेक बुक्स एंड व्हाट नॉट, राइट?
Well, to see the position again as another sort of position which is a breach of trust is that the active defendants, so that's Altaf Hussain, Mr. Iqbal Hussain, Qasim Ali Raza and Iftikhar Hussain, their position was very strange. For somebody who recognizes the very particular duties of a trustee, their position was very, very laughable because what they said is, we didn't know anything about the workings of the trusts. All of the things that happened in the trust were orchestrated and run by Mr. Mir as our accountant and Mr. Anwar as the accountant. They have all the records.
Yeah, but that argument is not going to hold in any court of law.
No, because that is their position in their defense. So unless they amend their defense and change their position, it's not going to hold. No, it's actually an abrogation of duty, fiduciary duty and duty.
I am so surprised that these are the people who are claiming to operate in urban Sindh for millions of people and be part of the governments and represent them, and now they don't even know the laws of the land in UK, and they've been doing black and white, left, right, center, selling the properties, getting the money, transferring the money, doing all kind of money funneling and here and there. And this is where people should be laying their trust on these people. They are supposed to lay, and I think rightfully they have taken back their position. So I am really shocked. It is really
well,
shocking.
You see, it's very simple, I think, and this is me speaking personally, not as a lawyer as such, but Mr. Hussain thought that the whole of the Jadad, the property and properties and money that came to the MQM was his own personal fiefdom, and the people around were serfs. They did what Altaf Hussain bidded, and that was it. And that was very obvious and patent in the way that the defense witnesses gave evidence. It was not so much an attempt to give information to the court to assist the court, but was more whether the answers to my questions would please Mr. Hussain, because he sat in the room with in the courtroom hearing the answers.
Seriously, I'm speechless. You know why? because this is the leader who claims to be a leader of middle class, lower middle class, poor people of Pakistan. And this is the leader who's not an illiterate person, who happens to be a graduate, a master's, who lectures people in the world economy and the Pakistan's economy, who lectures people on the world politics, and he does not know that simple basic law of the land, that this money does not belong to you. There is a system in place. You have to follow those guidelines, and you cannot. Ignorance is not an excuse in the court of law. Simple as that. Right?
Look, one of the things, just on that point, one of the things that shocked me, and it takes a lot of things to shock me, really, believe me, but it shocked me was when, in response to my question to whether he believed the constitution was the governing instrument of the party and was superior to everyone, Mr. Hussain frankly said to me, no, people swear allegiance to me, not the constitution. And the most important document in the party is not the constitution, but it's the manifesto. So for somebody who could not differentiate between a constitution and the purpose of a constitution and his own role in that constitution, and then also for somebody who thought that a political statement, a manifesto, was superior to the constitution and should be regarded more highly than the constitution, well, it speaks volumes.
So basically, this is the Altaf Hussain who claims to be the leader of a third largest political party of Pakistan, who has been in governments, many governments, in province and in federation, and he knows how the Senate, the legislature works. So he himself does not want to be governed under those political bindings. So basically it's like a Sicilian mafia, or like gangsters, like, okay, I am the man, I am the person, I am the only person people should reply, and I am not answerable to anybody in the world, right? This is irony.
See, I think I should be careful with how I describe Mr. Hussain.
This is how I describe.
Yes. All I can say is what I heard in court. I was the inquisitor, and the answers I got, really, I was astounded. The judge was speechless.
So there was a drama happening in the courtroom.
Well, the very fact that, you see, we're speaking to a high court judge, very highly educated, middle-class individual, who is very sensitive to issues and so on, and alive to the case, and he hears from Mr. Altaf Hussain that I'm more important than the constitution.
Oh my God.
Then what sort of impression does that leave?
मैं कानून से ज़्यादा अहम हूँ, मैं कानून से ऊपर हूँ, मैं कानून से बालातर हूँ, और ये एक आप कह रहे हैं लंदन के, बरतानिया के एक जज के सामने वो उसने अपना सर नहीं पीटा, तो फिर क्या किया होगा, या मैं अपना सर ना पीटूं? नाज़रीन,
if you want it, you can have the transcript.
And it is in the transcript, right?
I can send you the copy.
I will have to write a book in Urdu and explain my viewers what has happened in the courtroom, what kind of drama Altaf Hussain has played. And
it was, you see, this is, I think, this was a celebrity case in a sense, because the back of the court, there were really usually up to 100 people or more.
But there is a constitution which I think one must remember is of 2015.
Oh yes, the 2015.
Right? Now this 2015 constitution is in favor of Mr. Hussain, and but then what happened in the court?
You know, the 2015 constitution, the MQM London, or Mr. Hussain and his friends, became very fixated on this 2015
because they were insisting on that, right?
Well, they were, because they said that 2015 constitution had been adopted by the Rabta committee and assented to by Mr. Hussein. Remember the 9B clause that we talked about?
Yeah.
And the thing is, they also said that this constitution was adopted by the Rabta committee on the 21st of October 2015, and that it was assented to by Mr. Hussein on the 22nd of October 2022. Mm-hmm. And you will know that Mr. Hussein usually does not leave his home. He conducts his meetings and so on over the phone from his bedroom.
Yep.
So the Rabta committee was at Elizabeth House, I think, in their office, in their central secretariat.
International Secretariat. Yeah.
That's right, and he was at home. Mm-hmm. So what they said was they pinned their hopes to the 2015 constitution, saying that that was the one that was more powerful, and it was adopted, and it was always the constitution that existed from that moment. Mm-hmm. The difficulty they had was they couldn't prove any written statement or document or a minute that said such constitution had been adopted. And one thing that didn't help them, or rather two aspects of their peculiar behavior that didn't help the MQM London, was they have a recording mechanism in their office, an automatic telephone recording system in their office. So that was one element. The second was that since the beginning of time with the MQM, Mr. Hussein's speeches and the conversations are all recorded in a TDK tape. You know, the cassette, the audio cassette. Yep. That we had, the little magnetic tape.
So did you not ask for those tapes? Were they handed to you?
This is it. You've asked a very good question. We did ask.
Oh, you did ask.
And they shilly-shallied. They said, we can't find it, we don't have it, and so on. So a week or so before the trial, there was what's known as a pre-trial review, a PTR. And we made an application in writing, and then we followed that up with oral submissions in the PTR. And the judge made an unless order. Unless you provide these tapes or the telephone recording, your case, that element of it will be struck out. So you can't rely on the 2015 constitution. So under the threat of an unless order, they provided us with tapes.
They were withholding that information and not providing it to you?
Yes, effectively. But they did. Mm-hmm. Ultimately, they did. Mm-hmm. Now, the thing then was that Mr. Hussein obviously relied on that, and they gave us two specific dates, remember, the 21st of October and the 22nd of October, right? So you would have expected that the tapes that automatically record will record the conversation and the meeting that approved the Constitution, the 2015, and you would also have Mr. Hussein's assent recorded in the tapes. Well, I listened to 6 hours of tapes.
Oh God!
In Mr. Hussein's solicitor's office, the original tapes, and I heard not a single word about the 2015 Constitution. I heard a lot of words about who makes the best halim and the best biryani and so on, but I never heard anything about the 2015 Constitution.
मुतहदा कौमी मूवमेंट के बानी कायद रूहानी बाप अल्ताफ़ हुसैन जो है वो टेलीफोन पर अपने आइन, कॉन्स्टिट्यूशन, लीगैलिटीज़ के बारे में बात करने के बजाय हलीम की रेसिपी, निहारी कैसे बनती है, खुशगपियाँ और यही कुछ करते रहे और संजीदगी से इन मसाइल पे उन्होंने तवज्जो नहीं दी। नाज़रीन, ये 2-3 करोड़ महाजरों के रहनुमा की बात कर रहा हूँ मैं। इससे आपको इनकी संजीदगी और इनकी जो सियासी बालिदगी कह लें, बलूगियत कह लें, उसकी मैं आपको तरफ इशारा करना चाह रहा हूँ कि बिहाइंड द सीन जो कुछ होता रहा है वो बहुत कुछ और भी, और हम आने वाले दिनों में और भी लेकर आएंगे। बट ये अब जो बैरिस्टर साहब के आपने ज़बान से ख़ुद सुन लिया कि 6 घंटे उन्होंने बैठ के वो टेप सुने, उसमें कोई भी ऐसी कानूनी बात नहीं हुई, बल्कि बात खाने पीने की, हलीम पकाने की और निहारियों की बात होती रही।
Nihari. I forgot the Nihari because it's
Biryani.
Yeah. Biryani Nihari as well. Now, but the other issue was they said, well, look, maybe we didn't switch on the tape.
Okay.
So that's why that conversation wasn't recorded. Okay. So we argued the first day you didn't switch on the tape, the Rapta committee, but the second day, surely you must have switched on.
Somebody must have noticed, right? Yeah.
Yes. But then again, the default position was, remember the conversation was on the telephone. Mm. And the MQM office since 2014 odd had a automatic recording system in their telephone system.
From the British Telecom, right? Was it?
Yes.
Yeah.
And
so the British Telecom by default was recording on their own request, right?
That's right. And these were digital recordings.
So
we asked for those.
Yeah.
Now, their answer to that was, and this is even more incredible, was Mr. Sufyan, one of their members, who apparently is an engineer and is technically minded, inspected the hardware in their storage facility and decided that these were all redundant and decided to throw them out. And in amongst that, this BT recording instrument was thrown out. Actually, we put it rather cynically. We said that was an exercise of deliberately destroying and interfering with evidence.
Right.
And nonetheless, we proved our point that in the absence of the BT machine, confirming that the 22nd and the 21st and the 22nd meeting happened, and the absence of anything on the tapes which they gave us meant that the 2015 Constitution was never adopted. But legally, the other issue was of course, they never thought, and I don't know who advised them, but they never seemed to have thought the fact that the Election Act 2017 and the 2002 order required that an amended constitution or a new constitution must be lodged with the ECP within a certain days, I think.
Yeah, so Election Commission of Pakistan needs renewed kind of constitution from each political party, and that includes.
It's a legal requirement.
It is a legal requirement, yeah. And at that time, the 2016 version was submitted, I believe.
Yes.
Okay.
In 2015, the version of the constitution that was in force was the 2012.
Okay. So 2015 did not exist anywhere.
No. Okay. No, it was a draft. It was a working draft.
Okay.
And it was introduced into the proceedings, in fairness, not by the MQM London, but by the claimant in error.
Okay.
And when we realized this was an error, we resiled from it right away in our pleadings.
So the only hope for Mr. Altaf Hussain, which is 2015 draft constitution,
yes.
Either their evidence were not available, were thrown away, destroyed, and there was no proof available, and it was not even submitted to the Election Commission of Pakistan.
It was even more fundamental than that. Okay. It was even more fundamental than that. And again, you'll be astounded. You see, we had a constitution. When I went to Karachi to do my research, we met a very nice gentleman called Sayyid Sardar Ahmed.
Ji, Sardar Sahab.
He was the author of the 2015 Constitution. And he actually gave me the original Constitution, the draft, and he had written that in August 2015. In fact, on the 15th, he completed it.
Okay.
But then in the evening or sometime during the 15th of August, he realized there were errors in the Constitution. And he marked those with red ink, etched them out and so on. He gave me that original.
Yeah, just to
and
highlight.
He's given me that, and I have it in my storage upstairs.
Is this the original copy he gave you?
The original.
Oh, okay. Because in the court, I think they were also not happy with this highlighted photocopies and.
No, that's a different issue.
That's a different issue. Okay.
Yes, but you see, the 2015 Constitution was riddled with errors. there were so many errors and so many blanks where it would have said a committee of X would have members of Y. Those were blank. And their explanation was, well, we are continuing to adapt this constitution. We are continuing to evolve it. But a constitution for an association is a contractual document. You can't have an incomplete contract. So they were defeated on that fundamental point, that the document that they relied on was full of errors, and they had failed to check it. They had failed to check it. And so going back to the issue of the redaction.
Yes.
That relates to the 2016, an amended version of the 2016 with the Electoral Commission of Pakistan.
Okay. Was that the final version?
That, to me, that was the final version at that point.
Okay.
But it was
and it had some highlighted yellow.
It was highlighted.
Yeah.
Yes, it was highlighted with one of those markers, and because it was either green or blue. So
in photocopy, it's going to turn out as a gray or black.
That's right.
Yeah.
And the Election Commission did not give us a clean copy for whatever reason. But you could, if you looked at it, you could read what it said.
Right.
In the highlights. So it wasn't, as they say, a deletion or a redaction. It's a pretty silly suggestion to put forward that I or my team or my client, Mr. Aminul Haq, would make such a crude emendation on a legal document.
Yeah, exactly.
I mean, the judge actually says in his judgment that it was redacted to the point, it was highlighted to the point of redaction.
Right.
So you could see, and he actually read out the words. So they're in the judgment. So this fallacious argument that we fooled or trying to fool the judge is misconceived.
Okay. Let's move forward with the judgment now in hand that these properties do not belong to Altaf Hussain. They should be part of the trust. Trust belongs to MQM Pakistan. Whatever happens to these properties, the proceeds shall be the part of the trust, and the trust is owned by MQM Pakistan. Now, I believe there are certain properties in question. One of them, Mr. Hussain lives. One of them happens to be his own home. I believe it's 3 High View something in London.
The 3 High View is his own personal property.
That's his personal property, yeah.
Yeah.
I'm not talking about the Mill Hill property. Mill Hill is owned by the
That's right.
and the Edgware Road ones are 2 Edgware houses, and there's one more.
Yeah.
So
they're all trust properties.
They're all trust properties, right? So now I believe that there has to be an execution of the judgment. Is it happening this month or so, like 16th of May or something?
The 16th of May is what we call a consequential order.
Consequential order.
So, so you see, the judgment that was given was a finding of fact based on law and evidence. Now, those declarations have to be put into an order, and they have to have certain consequences, and that's why it's a consequential order.
Okay.
One of the consequences will be that we will be declared as the trustees, the beneficiaries of that trust. We will be given the power to change the trustees. We will be given an account of those properties and the rents that they've collected over the years, the rents that they're going to collect. And one of the things we'll be seeking is that all those rents, rather than going to either Mr. Hussain or some other person or body, they should go to an account that is operated by the MQMP for the benefit of the MQMP.
Okay. Okay.
But also that we should have control of those properties. And it may mean that Mr. Hussain, if he can't afford the rent, will have to move back to his own home or pay the rent like anybody else would do, because beneficiaries benefit from the trust, The trustees are not meant to and cannot by law.
They cannot use it for their own self or own purpose.
No, it's self-dealing. It's self-dealing and not permitted. Therefore, he cannot, and he has been. So therefore,
now I believe there are a couple of properties in question where some of the MQM executive committee or Rabta committee members were residing as their principal place of accommodation, and they were I don't know, reportedly they were paying rents to Altaf Hussain, and then again Altaf Hussain was paying them a kind of a stipend or kind of a salary back to them. So this was going in a circle.
I cannot comment on the stipend because that's not part of our pleaded case, and we don't have any evidence. It might surface in our disclosure request.
But rent was being paid to him.
Rent is part of our case, that rent is being paid to Mr. Hussain.
Now, where did that rent go? Where is the paper trail?
It would be, since it's not accounted for to the beneficiaries, it therefore being misappropriated either by Mr. Hussain or utilized for some other purpose which he is not authorized to do so.
Okay. And the house where Mr. Hussain is living, Mill Hill House, he's been living there for so many years. He owes that rent that much.
Well, yes, he would, because it's never been his property. It's a trust property.
So that is a trust property.
12 Abbeyfield. That's
12 Abbeyfield, yeah.
Residence, yes. That's where he lives. And all of these properties that he has either through his own, as we described earlier, his own personal fiefdom sort of situation, let out to people that are kind to him or people who support him, they will have to be accounted for. And it could run into very, very substantial amounts of rent.
What about the legal cost? Like, doesn't he owe legal cost also for this whole trial?
Well, our pleading always have been, and it will remain until the end, is that the defendants are jointly and severally liable for our costs. So Mr. Hussain has so far, I think, been responsible for all the costs of his lawyers, it seems. He may end up paying our costs, which could be over 100,000. But certainly one of the things that we will have to do is to secure our clients' best interests, and that will include charging the properties, at least those of those defendants who own their properties, to charge those properties in respect of our costs and any judgment. So that charging will probably be applied for after the 16th May hearing.
So by 16th May hearing,
on-house.
Does he have an option of going against this judgment, appealing for it?
You see, Farooqi Sahab, an appeal is open to anyone. However, there is a technical basis for the appeal.
Right.
An appeal simply because you disagree with the judge's findings is not a point that is likely to succeed.
Right.
And it isn't an appeal that will succeed because a appellate court does not likely interfere with the factual findings of a lower court.
Okay.
The simple reason for that is the lower court hears the evidence, sees the demeanor of the witnesses, all the drama of the case is there. An appellate court receives a sterile summary of things. So there isn't, in my view, a legal argument to be made for an appeal, but they can try. However, an appeal is a gated procedure, okay? So they will have to open the gate to go through to a substantial hearing. Now, substantive hearing is the appeal. The permission is merely to open the gate, and they will have to ask the lower court first for permission. If the lower court refuses permission, their only other option then is to go to the appeal court directly. And in this case, because this was a high court decision, the next upper court is the Court of Appeal, which is second to the Supreme Court of the United Kingdom. Now, the thing with the appeal is very, very interesting. If the appeal is refused on the papers, okay, at first instance, if the permission is denied and they go and appeal on papers to a single judge, if he refuses, he may give them permission to bring an oral application to elaborate on the reasoning that the first judge has refused the appeal. And if those attempts fail at that stage, that's it. There is no further going forward, because there is no appeal in English, the English legal system, for an appeal from a permission stage. So it may be a very sort of shortened and curtailed process, which would probably do us well, because that will just kill the case.
Okay. Okay. So what are the chances? Like, do you see that there's any slim chance of Mr. Hussain succeeding, securing an appeal and prolonging this execution consequential order?
Well, there's two things there, without being too dogmatically legal about it. The first thing is, an appeal does not stop or stay the execution of the lower court's order. That's not an automatic process.
Okay.
You will have to ask the appeal court for permission to do so. And if he gets permission, their position is quite considerably strong to seek a stay. Okay? But even if they did, and the appeal court says, well, no, the removal of the trustees can take place, the accountability can still take place, but we will stop you being evicted, perhaps, that might work. The reason for that is, you see, if you look at the judgment as it is, the judge has actually identified very clearly, and I don't think it's sunk in to Mr. Hussain and his colleagues' brains at the moment, that what the judge says is the issues of the 31st of August with regards to whether the Constitution was legally amended or otherwise, yes, is not a barrier to
the trustee issue.
Yes, the trust issue is not a defense.
Yeah.
And the judge puts it very prosaically. I won't bore you with it, but if you look at the judgment, what the judge says is, look, if a trustee steals from his beneficiary, and then the beneficiaries complain, and the trustee says, well, there was some fault in the Constitution, that doesn't negate the breach.
Right.
And this is the analogy that the judge gives, and I thought that people would recognize that very simply, but they haven't.
So these are two separate issues, and they have to be dealt separately. There is a one severe violence, and then there's a smaller kind of a technical, ground.
The other technical issue is that the issue of the constitutional issue, and it's probably why the judge didn't really didn't deal with it really. The 2/3 majority or not for the amendments in on the 31st of August is because that is for the Pakistani court to resolve under Pakistani law.
Right.
And this court did not feel right from the beginning able to deal with that issue.
Right.
So it skirted away from it.
Right.
But made it very clear that the trustees are in England, the properties are in England, and by and large, most of the trustees are British citizens. English law applies, full and square.
So are you able to calculate altogether the damages that he has to pay back? What kind of ballpark figure we are looking at that he owes the beneficiaries, including the legal cost?
Well, it would be no less than 10 million.
10 million pounds we're talking about?
Yeah.
And we all know that he does not have that kind of resource. So what's going to happen then? Default if he doesn't pay back?
Well, you see, look, this is again, the advice I give to clients when they come to me and say, look, we want to sue Mr. X or Miss Y. And I say to them, well, is Mr. X and Miss Y worthy of being sued.
Right.
Not everybody is worthy of being sued.
Mm-hmm.
And if Mr. Hussein proves to be a man of straw, and my clients then say, well, if he can't pay, the judgment will have to be enforced. Well, remember, we will have put a charge on his property so we could sell his property, his own personal property.
Right.
And that of his other defendants.
Right. So you can go after their personal assets.
Oh, yes, because they'll be jointly and severally liable. That includes Mr. Iqbal Hussein
in America,
in the United States.
Okay.
Now, because we have his property details.
So you have his property details in the United States, Mr. Iqbal Hussain, the Altaf Hussein's elder brother?
Yes.
Okay.
We do. We obtained them. They're public documents. There's not a big issue.
Right.
I'm fortunate enough to have
what if they have invested the money outside UK, for example, Canada, for example, Australia, from that trust money, and they bought businesses and properties here?
Well, you see, the thing is, what will happen is after the consequential order is made, we will be following up, because we will then be entitled to, and we will receive bank account details, property details, and so on. And of course, as you know, you can then trace from A to B to C.
Yeah.
And unless money was taken in suitcases and handbags and things like that, there should be a clear trail.
Yeah.
And these properties can be traced into. And it all depends on how zealous my clients are for following things.
Right.
But there are legal mechanisms for enforcing judgments. Now, one interesting point that arose was whether a judgment of the United Kingdom, the High Court in the United Kingdom, English High Court, the judgment of that could be enforced in Pakistan. And there is a mutual agreement between Pakistan and the United Kingdom, as with many other countries mutually, that a judgment on application to a district judge in Pakistan can be enforced. So this judgment can actually be enforced against personal assets of these people in Pakistan, can be enforced against other properties. Now, one property in obvious point is the MQM 09 or 90.
Yep.
That is now an MQM-P property.
Right.
Legally, and this judgment could be used to enforce the ownership of that in favor of the MQM-P.
Right.
And any assets that, for example, if we can't find assets in the United Kingdom to enforce against, well, assets of these people in Pakistan can be enforced against.
Yeah, and once you have the bank details, then you would have more clear picture that where was the funds transferred, where were the investments made.
The money laundering case,
exactly,
although it failed, it generated a lot of data.
Oh yes.
And the raid on his properties generated a lot of data.
Right.
And most of that data is still retained by the Metropolitan Police.
Mm-hmm.
So under third-party disclosure orders, the Met Police can be ordered to provide those documents and those records. So even if Mr. Hussein now says, well, all of my data went with Mr. Mir and Mr. Anwar, and they won't give it back, Mr. Mir denies having any records. Mr. Anwar is dead. But the Met Police is still alive.
Right.
They have their records. We could ask a High Court judge to order the Met to disclose those documents.
And you never know, somebody can turn to become a crown witness, and then things will another can of worm will open.
Yes, but as you said, dots can be joined.
Right.
But see, my remit as a lawyer, as you'll appreciate, is to act upon instructions. And if my clients say, well, this is it, please forget any further action, we are satisfied, and that will be the end.
Exactly.
For me, I'll move on to something else. This isn't my lifetime's work.
Exactly.
Yeah, I have other things to do.
Well, it's a high profile for you.
Sorry?
It is a high profile case, like you said, it's a celebrity case.
It's to be honest, it's a case. I treat all my cases with as much detailed attention as I can. So
now, speaking of that, treating your case, which you did very good job, the Altaf Hussein's colleagues, the witnesses, the directors, the trustee, did you find a lack of knowledge and preparation on their part? This case could have gone in their favor?
Well, I don't know about the favor, but the quality of evidence for me was very unsatisfactory. I think if my witnesses were given the sort of evidence that I elicited from Mr. Hussein's witnesses, I'd be sitting in the back of the court cringing and crying.
Right.
I give you a prime example. Mr. Qasim Ali Raza and Mr. Aziz Abadi, Mustafa Aziz Abadi, I think. Their evidence was so contradictory.
Their own internal, in between both of them.
Yes, because they're not only was it internally very contradictory, but it was also contradictory in terms of, remember, their main plank, or the main plank of their defense was the 2015 constitution had been adopted. And you see, in April 2016, there were elections to the Rabta Committee. Okay? And the 2016 constitution contained a procedure for that election to take place, including the procedure for co-opting people on to the committee. Now, Mr. Mustafa Aziz Abadi, now I forget which one of them was elected, but one of them was elected to the Rabta Committee in April 2016. And so I said to him, well, this is the situation. The notification from the returning officer says that these people were elected under Section 13, pursuant to Section 11 of the 2002 order. Notice is given hereby, or words to that effect. I paraphrase. And so I said to them, do you not see the contradiction here? When we look at the 2015 constitution, the relevant clause, which it should be 2013 by this notification, does not relate to elections at all. It relates to a matter totally unrelated. But clause 17 or article 17 relates to elections, and it does not include a co-opting procedure. The reply was, we accept that the election took place under 2016 constitution because by that time we hadn't fully adopted the 2015 constitution. We were adopting it in phases. And how can somebody accept that answer? And they seriously fought for that answer. And I personally was astounded that how can you, as a lawyer, or even as a layperson, and somebody who is familiar with the working of the Rabta Committee, somebody who had sworn on oath and confirmed for inquiries at the outset under Part 18 to say that the 2015 constitution that they had relied on was complete.
Right.
Now, in court, under oath, you're saying you're implementing it in phases, and you just decided to hold the elections under the provisions of the 2016 constitution.
Right. Right.
A child would see the contradiction.
Exactly. Yeah.
And so that is the sort of thing. By contrast, our witnesses, which included Dr. Sattar, Dr. Nusrat, Mr. Aminul Haq, and Mr. Wasim Akhtar, the former mayor, they were well prepared, well versed, and their evidence was very cogent, very to the point, and the judge individually has commented on his findings and the demeanor of each witness individually. That's why the judgment is so long.
Funny that you brought this point. I have been telling Mr. Hussain, if he is listening to me, अल्ताफ भाई, मैं आपको कब से कह रहा था कि अपने इर्द गिर्द पढ़े लिखे लोगों को रखें, मुंशियों को रखकर आज उन्होंने आपको इस हाल पे पहुंचाया है। और उनके उसके मुकाबले में जो आपकी पढ़ी लिखी क्रीम थी, जिसमें डॉक्टर फ़ारूक सत्तार थे, जिसमें अमीनुल हक थे, जिसमें वसीम अख्तर थे, जिसमें राब्ता कमेटी के मेंबर थे, इन लोगों ने 2-2, 3-3 घंटे की टेस्टिमनी दी है बरतानिया के जज के सामने, पाकिस्तान के वीडियो लिंक पे बैठ के, और उन्होंने दलील के साथ गुफ्तगू की है, जो कि कन्विंसिबल गुफ्तगू की थी। लेकिन आपने बात कभी नहीं सुनी, और आपने उन्हीं मुंशियों को रखा जो आज आपसे ट्वीट भी करवाते हैं, तो उसमें ना सिर्फ स्पेलिंग मिस्टेक होती है बल्कि ग्रामर की मिस्टेक होती है।
The case that we prepared, we spent many hours preparing it. We went over every single detail, and most of the credit would go to our witnesses, who were very well prepared, and they put in the time to study the documents, and they knew what they were talking about and the subject matter. By contrast, I'm afraid to say, and I'm not demeaning anyone or any individual, it's not my role, but I have to say, if I had to, an objective observer, if I commented on the quality of the evidence that came from Mr. Hussein's side, it was very poor, and unfortunately, the witnesses that we had, I don't think, and one of the things I think influenced the case was the legal team for Mr. Hussein. They did well, of course, I mean, to serve their client as well as they could. But one of the things they, I think, made an error on was didn't anticipate the quality of the evidence that would come from our witnesses.
Right.
And their ability to articulate their answers. Most of the evidence that I got from Mr. Hussein's witnesses was argumentative.
Not only that, what I hear, and I know this for the fact, that Qasim Ali Raza, if you put Qasim Ali Raza or Mustafa Azizabadi on a stand where their Rouhani Baap is sitting in front of them on the chair, they would be just pleasing him. They would not be arguing for the sake of argument in the court based on technical grounds or the legal ground. They would be appeasing him. They would be making him, like smile, and when they go back home, he's going to give a pat on their shoulder and say, Shabash, bahut acha kaam kiya, very good, maza aa gaya. But this is what they did. I think they were scared of their leader in front of them, and they usually they say ji bhai, ji bhai, ji bhai. They have said nothing in the whole life other than ji bhai, and they did the same thing in the court.
I don't know anymore. I don't know much about how they relate, but
this is how MQ work, Barrister Sahab.
The judge picked it up, actually, in a sense. He said, look, most of the evidence that's been given is tainted by this desire to appease Mr. Hussein and his reaction. And you can pick that up. You can see that clearly in the judgment.
It is in the judgment. That's where I picked it up from, that even judge noticed that these people, okay, I'm going to restrain myself, these people did not put their case properly, and they were trying to please Altaf Hussain, or maybe scared of them, or out of respect, and their usual practice, as if they are sitting in their own international headquarters, and ji bhai, ji bhai, ji bhai, adab, 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 ji bhai, and this is what they did. And in the end of the day, they were ill prepared. They did not put the case properly. They did not put their witnesses properly, and then we cannot blame anybody just but them. And I know Altaf Hussain would be shouting out of his lungs on these two people that tumne mujhe marwa diya.
You see, Farooqi Sahab, as I say, I'm sure Mr. Hussein is disappointed in the outcome. But all I can say is we prepared very well. We were well prepared.
Yep.
The fundamental error that they also made was, remember, these were trustees. They should have actually followed procedure fundamentally. The day that I personally served the claim on each individual person, I went round in my car with my colleagues, and we drove around to each individual house, and we dropped off the claim. they should have spoken to their lawyer, and the lawyer should have said at the beginning, look, we need a Beddoes order.
Exactly.
Okay? A Beddoes order is a very special process.
That is a very valid point. Can you explain that again, please?
Okay. Because this was a trust act, the beneficiaries were suing the trustees.
So you're saying there is a way that they could have avoided all this liability on them?
Yes, they could have.
There was a way?
Yes, because you see that there would have been the consequences of the Beddoes order would have been twofold. First of all, a Beddoes order is a process, a claim in itself. That would have explained to Mr. Hussein whether he was able to contest these proceedings or not, and whether it had any chance. And if there was a bona fide case, the court would have given him directions to say this is how it should be contested, and it would have ordered that he be protected personally together with the other trustees from any cost consequences. See? And that would have saved all of these problems for him now.
So the question here is, was it not a responsibility of someone to advise them to seek this, or somebody missed it out, their error or omission on that?
I don't know whether it was an omission, whether it was a deliberate decision not to seek a Beddoes order, but the judge did point out right at on the very first day to say there is no representation order here under CPR 19. CPR means Civil Procedure Rule 19. It is a rule that dictates how representative defendants or representative claimants should be protected from this kind of consequence. We, on the other hand, had a resolution from the MQM committee, the Raptor committee, authorizing Mr. Aminul Haq to be the representative claimant. Right. And it is written on the claim itself, representative claimant. And this was not done for the trustees, unfortunately. So they are now.
अल्ताफ भाई, आपको मेरी अगर आवाज़ आ रही होगी और सुन भी रहे होंगे, देखेंगे भी आपको किसी ने मशवरा नहीं दिया था कि ये बेडोज ऑर्डर ले रहे हैं? मतलब आप पूछे तो सही ज़रा अपने दोस्तों से, अहबाब से, जिन्होंने आपको बहुत सारे कानूनी माहिरीन भी जमा किए, आपने पैसे भी खर्च किए, तो एक इतना अहम नुक्ता भूल गए और उसकी वजह से आज ये सारी की सारी जो पेमेंट की जिम्मेदारी है, लायबिलिटी है, ये आप पर आ रही है और आपके राब्ता कमेटी के लोगों पे आ रही है। ये बड़ा वैलिड पॉइंट है अल्ताफ भाई, इसको आप ज़रा इसकी तहकीकात करवाइएगा इस प्रोग्राम को देखने के बाद। So this is my advice in goodwill.
See, as I say, I'm not the advisor, but I mean, for them, all I'm saying is that it was picked up by the judge,
right? And
it was something that is a fundamental step.
It is a basic, fundamental, बुनियाद, असास, सारी चीज़ें पता है आपको अल्ताफ भाई। Well, thank you so much, Barrister Nazar Mohammad Saab, joining us from London. Really appreciate all your input. And we look forward to be hearing from you more developments in the coming days.
Of course, I'm very grateful for you to have.
Thank you for enlightening our viewers because there was some confusion, which I hope we got clear. So viewers, ये थी आज की हमारी इस 1.5 घंटा तवील प्रोग्राम की दास्तान, जिसमें कि अल्ताफ़ हुसैन साहब के मुकदमे की बात हुई, जिसमें कि अल्ताफ़ हुसैन साहब की प्रॉपर्टीज़ की बात हुई, MQM की ओनरशिप की बात हुई, उसके अलावा उसके बाद क्या होगा, ये रकम कैसे अदा होगी, कौन घर से निकाला जाएगा, कौन किस घर में जाके रहेगा, और उस घर में रहने के बावजूद भी उनको वो अदायगी करनी है। अब ये मुनहसर है मुत्तहिदा कौमी मूवमेंट पाकिस्तान पर कि वो इस मामले को कितना आगे लेकर जाती है और उसके बाद ही कोई फ़ैसला किया जा सकेगा। अपील का जहाँ तक है बहुत स्लिम चांसेस हैं, बहुत माइनर इस तरह की प्रेसिडेंट मिलते हैं कि इस तरह की अपील मंजूर हुई हो, लेकिन उनका हक़ बनता है वो अपील ज़रूर करें, लेकिन इस बात पे ज़रूर गौर करें कि कहाँ गलती हुई है, किस तरह से अपने आप को एक मुतलक़ुल अनान बेलगाम आपने समझकर इस सारे अफेयर्स को हैंडल किया। गरीबों, यतीमों, मस्कीनों, असीरों का हक़, जो प्रॉपर्टी जो बनाई, जिसको अरबों, जिसमें कहते हैं कि अब 10 मिलियन पाउंड्स उसको आप कन्वर्ट कर लें पाकिस्तानी रुपीज़ में, वो आपने अपने ज़ात पर, अपने लोगों पर, उनकी रिहाइश पे ख़र्च किया, अपनी अय्याशियों पे ख़र्च किया, अपने बिजनेसेस, अपनी एम्पायर पे ख़र्च किया, कोई हिसाब किताब नहीं रखा, اور اس کے بعد آپ کے ساتھیوں نے، آپ کے رفقا نے بھی اس بات کا دھیان نہیں دیا، کیونکہ وہ بھی ایک اچھی زندگی لندن میں گزار رہے تھے، ان کو کیا ضرورت پڑی تھی کہ کام کرتے، اور وہ آج کورٹ میں وہ اپنا آپ کا صحیح سے دفاع بھی نہیں کر سکے۔ پاکستان کے عوام جس شخص کو اپنا مسیحا سمجھتے تھے، جس انسان کو قائد سمجھتے تھے، باپ سمجھتے تھے، ان کی جو یہ باتیں اب دھیرے دھیرے کر کے سامنے آ رہی ہیں، تو احساس ہوتا ہے کہ پاکستان کی عوام کو پاکستان کے ساتھ رہنے والے لوگوں کے ساتھ مستقبل بنانا ہوگا، ان کے ساتھ ہی جڑنا ہوگا، آگے بڑھنا ہوگا، اور یہ متحدہ قومی موومنٹ کی بھی ذمہ داری ہے، جو کہ متحدہ قومی موومنٹ ہے پاکستان میں، جو کہ مصطفیٰ کمال، خالد مقبول صدیقی، ڈاکٹر فاروق ستار، فیصل سبزواری، اظہار الحق، امین الحق، ان سارے احباب کے ساتھ اس کارواں کو لے کے چل رہی ہے کہ خدارہ اپنے اندر اتحاد اور اتفاق کو اور مضبوط کریں، اپنے آنے والے الیکٹورل نظام پہ توجہ دیں، اپنی سیٹوں کو واپس لیں، اپنے آپ کو واپس لیں، بلکہ سیٹوں کو بڑھائیں، اور تمام مقامی غیر مقامی رہنے والے لوگوں کے دلوں میں اپنی جگہ بنائیں، ان کے لیے بھی اپنے امیدوار کھڑے کریں، اور ایسے امیدوار کھڑے ہیں جو سب کو قابل قبول ہوں، تاکہ اس شہر کا مستقبل اچھا ہو، یہ منی پاکستان کا مستقبل اچھا ہوگا تو میرے پاکستان کا مستقبل بھی بہت اچھا ہوگا۔ ناظرین کرام، ہم آج تک یہی تک لے کر آئے تھے، مزید ہمارے پاس اور نیوز جب آئیں گی، آنے والی ہیں، اس پہ ہم کام کر رہے ہیں، آپ کو ضرور بتائیں گے۔ انیس فاروقی کو اجازت دیجیے گا۔